So, as I said, welcome everyone, and we at the VCAT team are delighted to be part of Law Week. It's always a great opportunity to speak to the community about legal issues, about the way that law interacts with people's lives, to give answers to some basic and sometimes more complicated legal questions, and just to update people essentially on what's happening in the law and the court's jurisdictions in particular. A little bit about VCAT. VCAT is Australia's busiest tribunal and resolves many thousands of matters every year, something in the region of 80,000 matters, all really with the aim of ensuring that people can put their legal issues behind them and move on with their lives. It's difficult to sort of neatly summarise the breadth of VCAT's jurisdiction. It covers really a very broad range of everyday disputes, such as renting, consumer, building and planning disputes. And people can also come to us if they need to appoint a guardian for a family member or friend, and the monitoring of that guardianship process is a significant part of our jurisdiction. So on today's topic, closing the gap, improving Koori access to justice at VCAT. I joined VCAT in February last year, which was just prior to COVID, obviously, at a time when VCAT was already sort of partway on this sort of journey of transformation to improve the way that it engages with its Koori users and the Koori community more broadly. Over the preceding years, there have been a number of reports, including the 2016 Access to Justice Review, and the earlier sort of 2013 review on civil and family law needs of Indigenous people in Victoria, which had indicated really quite significant problems and barriers in accessing justice for Victoria's Koori community, including at VCAT. I mean, Aboriginal participation at VCAT had historically been quite low. Reflecting on the year that's sort of been the time that I've been around, it's been really quite remarkable and encouraging to see what the team that I'm about to introduce has achieved. In the face of disruptions through COVID, but also starting from a relatively low sort of starting point and moving into what is now in many ways a very sophisticated engagement and support program. So we've brought together our Koori support team that had been established only, as I say, in the early part of last year, and one of our members who are like our judges to talk about the work that VCAT is doing to create this innovative and culturally inclusive justice service for the Koori community. So with that, I'd now like to introduce our first speaker, who's Wendy Harris, who's leading the fantastic Koori support team and the Koori engagement program. Wendy's going to talk a bit about the approach that she and her team are taking to undertake that transformational experience for Koori people who are coming to VCAT to resolve their disputes. So Wendy, it's over to you. Thanks.
Good afternoon, everyone, and thank you, Warwick, for the introduction. My name is Wendy Harris, and I'm a proud Mandindangi woman from southern Queensland and was born on country in Roma. I've now lived longer in Victoria than Queensland and am passionate about working to make things better for Koori people here in Victoria, no matter which role I hold, that is. And I'm a proud public servant and particularly privileged to lead the Koori engagement and support program at VCAT since 2019. I'd like to also begin by acknowledging the Wurundjeri traditional owners and pay my respects to their elders past, present and emerging. I'm attending today from the Yarra Valley and I'm not far from Corandurk Mission, place, connection, land and history, and our ancestors being ever present for Aboriginal people. Why do I mention where I am and why it matters? Well, Corandurk Mission was established as a reserve for Aboriginal people of South Central Victoria, operated under Australia's first administrative framework to manage Aboriginal affairs, an approach later adopted throughout the country. Corandurk's residents fought against efforts to control their lives. Their sustained resistance is often cited as among the first Indigenous campaigns for land rights and self-determination. In 1881, Wurundjeri leader William Barrack said, "We can work, make it pay." And they did manage that land and make it pay, but this was not enough for the Victorian colonial government of the day to grant them the self-determination they were seeking. I make this comment as Aboriginal people in Victoria exactly 130 years later work towards real self-determination in this generation. So self-determination, across the Victorian government, departments and agencies have been tasked to develop their own self-determination plans. Our topic today is about Koori access to justice at VCAT. So our starting point is our overarching accountability to government, and VCAT has its own self-determination action plan commitments. These commitments and their related activities sit within the New Court Services Victoria self-determination plan. And I'd like to share with you what is happening at VCAT to make us a place of safety for Koori people, where our mob have a straightforward journey to the information they need, can prepare with the support of our Koori support team, and have the option to have their civil justice matter heard in a Koori hearing room, either in person or virtually. Our self-determination plan will be implemented, and our simplest measure of success will be if we have created an environment where Koori people have inclusive and supported experiences and see themselves as engaging equitably with VCAT. So, why do we know changes were needed at VCAT and what was the problem? And Warwick has started to build your knowledge base about that. We did have independent research undertaken by consultants, and that confirmed that the participation levels for Koori people with civil justice matters have been low, and that those barriers to participation include that VCAT's processes can be intimidating. In 2016, people told us things like, I was supporting a client, a female elder, in a VCAT hearing, and I knew she was very nervous and fearful. The member commenced the hearing by asking the client to read an oath or affirmation. I knew she was illiterate, so I tried to intervene and ask the member to read the affirmation and have my client repeat it. The member cut me off before I could make that request, told me I couldn't speak, and insisted again that the client read the oath or affirmation. My client reported later that she did not know what an oath or affirmation was, felt very uncomfortable about and embarrassed about having to try and read in front of a crowd, and that the situation brought back lots of bad memories of school and other painful experiences. Another participant in that research said, I had difficulty finding the right online form and then filled it out to the best of my ability. All parties took time off to attend the hearing. The member dismissed it after 2 minutes because the paperwork was incorrect. I felt terrible for wasting everybody's time, and I lost all credibility with my Koori client. A summary of those, what was found out in 2016 included that 70% of Koori's interviewed said they had little or no understanding of what was expected of them at a hearing, and 53% of Koori interviewees found it difficult to understand the hearing process itself. So fast forward to 2020, further research, what we were being told was, a Koori person with a civil claim said, I was worried about coming to VCAT. This was going to be my first time in seeing this guy since whenever. I didn't want to just sit there and bawl my eyes out. I was worried I might get bullied out of it by the person you put your claim against. An applicant to a residential tenancies matter said, for safety reasons, I would rather be in another room with video conferencing. As a renter, being in the same room with a property manager is hard. And a guardianship applicant said, I don't ever expect a positive experience from the justice system. Sorry, but I just feel that the odds are stacked against us. So to summarise, that research showed that many of the pains encountered by Koori people when navigating VCAT matters stem from a lack of understanding about what the process would entail and what to expect at hearings. In understanding what needed to be done to bring about a real internal cultural change, VCAT, with the help of the Koori unit at Court Services Victoria, was successful in securing funding for VCAT within the 4th iteration of the Victorian Aboriginal Justice Agreement. Together with VCAT's earlier recruitment of a Koori engagement manager, at the start of 2019, it was time to make a concerted effort to address the recommendations of these independent reports. So, What have we been doing to address what Koori people had been saying about their poor VCAT experiences? So, as you will see a slide at the moment, and this has a number of milestones that have been achieved to date. And I'll touch on just a few of those highlights now. So in 2019, as part of our foundational activities were that VCAT looked at the built environment changes that could be made, and this included making the case for Koori hearing rooms. And this meant how to create them with cultural cues, including oval tables to sit down together around, including the member, wherever possible, flags, Koori artworks, and possum skin cloaks, which add comfort for a Koori person attending a hearing. We also benefited from the knowledge built up at other jurisdictions' Koori courts. The other big part of our foundational activities was to recruit a Koori support team, and they are 4 roles. We have a team leader, 2 Koori support officers, and we also have a Koori engagement administrative officer. Then from 2020 onwards, our Koori team was recruited, was selected and onboarded. We developed a service delivery model and standard operating procedures, developed a client database and our reporting templates. We saw the commencement of the VCAT Koori reference group, including key stakeholder organisation representatives, and of course our 2 Koori VCAT members. And you'll be hearing from member Sid Fry, now in his 13th year at VCAT. User experience research project with Portable, and this led to developing culturally appropriate web page content that included videos, case studies, referral pathways, and our Koori brand artwork and logo. I'm wearing the Koori support shirt today. The VCAT website was relaunched in July 2020, and to date, over 4,500 hits have been made on the Koori landing page. So celebrating the successes and working to ensure it all works out as intended and into the future, the slides appearing show photos taken when we've launched new VCAT community-based venues. In order of completion, they were at Oakleigh, Frankston and Bundoora. So to Oakleigh, smoked on the 7th of February 2020, we have a Koori support officer, Sarah Bain. She'll be available at Oakleigh each Tuesday when in-person hearings recommence. Just bear with me a moment, sorry. Our Frankston venue officially launched on the 12th of March 2021. Sarah Bain will be on site at Frankston each Thursday. And most recently, our Bundoora venue officially launched on the 23rd of April 2021. Koori Support Officer Tracy Winmar will be on site at Bundoora each Monday and Wednesday. And cultural safety goes beyond the built environment, and Koori Support Officers reaching out. VCAT members are central to how Koori people experience their hearing. So members' hearing matters. Where it is known that a matter includes a Koori person, these members will have had cultural awareness training and experience in hearing matters involving Koori people, such that they bring this higher level of Koori cultural competency to their method of conducting hearings. The Koori team is available to continue this applied cultural knowledge at future professional development days. As a service been taken up by the Koori community since we began in early 2020. We have some statistics to show you. So it was assumed that when we actively search for Koori people coming to VCAT, that most would be involved in residential tenancy matters. Well, that may well be the case at some point in the future, but while we've been busy delivering support services during COVID and with an evictions moratorium in place, our current caseload of 76 cases at the point of producing this slide reflects that our highest caseload is actually in guardianship matters, followed closely by residential tenancies and civil matters. A smaller number on the human rights list, planning environment list, and also the review and regulation list, which is that list meaning is that's where people go to have a government decision reviewed. They are also within our current caseload. Noting that our team was only 50% complete and only in the early stages of induction when COVID changed everything, changed our path to a service delivery model, we were literally all learning together on the job. So this is without having an ability to yet do an intensive community engagement, which will naturally increase the numbers of Koori people we support. If you ask me what would be a best case scenario for Koori people coming to VCAT from here forward, I would say that Koori people knew that our VCAT Koori support webpage exists and found their way there, making use of the videos, case studies, referral pathways that are within that webpage. They would know that they could reach out to the Koori support team via our Koori helpline. They would know that a Koori support officer will call them back and provide real assistance to navigate VCAT's processes. They would know that there is an option to have their matter heard in a Koori hearing room, whether in person or virtually. That we list Koori people's hearings back to back in our community venues on the days that our Koori support officer is on site for in-person support. That our highly culturally competent members hear the back-to-back matters that involve Koori people. This is what we are hoping is the beginning of a Koori hearing day or a Koori half-day hearing listings model. That our post-hearing feedback tells us that Koori people felt the process was fair and they were prepared and were heard, no matter if they were successful or not in their matter. And finally, that the Koori community freely talked about going to VCAT as something they would encourage others to do because they trust that people feel supported, can get their business done, and then very importantly, move on. With that said, and to hear more of the frontline Koori support experience at VCAT, I'll now hand you over to VCAT's Koori support team leader, Kim Williams. Thank you.
Hi everyone. As Wendy just mentioned, my name is Kim Williams. I am the Koori support team leader at VCAT. I've been in the role for a couple of months now, but I've been with VCAT since January 2020. Where did that go? I work with the two other Koori support officers, Tracy and Sarah, as Wendy just mentioned, and we assist clients across all lists, which include civil, residential, tenancy, guardianship and administration. Today, I'd just like to share some insight on how we support our Aboriginal and Torres Strait Islander clients when they come to VCAT and support the community here in Victoria. The guardianship and administration list has been the busiest by far over the last year, and it's our aim to have a Koori support officer provide support to these families and attend their hearing on the day. May not always be the case, as you know, things are only going to get busier, so we might not get to every single one of them, but that's our aim. If we can't attend the hearing on the day, we at least make contact with all the parties that we can involved in the matter, and make sure that we provide support in the lead up to the hearing, which has proven to be beneficial to our Koori users so far. I've been working with one particular family in the guardianship and administration list over the past year. This family has been really broken. The ordeal that they were going through had created a wedge between family members long before it even came to VCAT. They were hurting and they were feeling very frustrated with each other, and the whole process had impacted their lives. So as you know, as well as working with the family, I made sure I reached out to the members that were hearing these matters to help them understand the cultural complexities and the family dynamics involved in this case, which the member said was very helpful to them at the time too. So it adds that extra layer of cultural support and safety for them. I've attended 4 hearings for this family so far over the last year alone, and it's not done yet, as I was the Koori support officer allocated to their matter. So I intend to sort of stay with them until it's seen right through, which is they also said was very helpful to have that continuity of service. The outcome may not have been what each family member wanted, and an administrator was eventually appointed, and they each had their own expectations on what the outcome would be. But ultimately, they all attended on the day every time, and they had their say, and they felt they were heard, which is what we're encouraging our people to do. In the lead up to the hearing, the support looks pretty much like this across all lists, but you know, sometimes it's different across different lists. For guardianship, there's a lot more that you have to do to make sure that you're there for them throughout the whole journey. But you know, you give reassurance around the hearing process and let them know what to expect on the day. You know, talk them through what a teleconference would look like and how a hearing would be conducted by phone. Explain the roles of a guardianship or a guardian or administrator, so they knew what to expect. And I provided referrals to support services as they needed them. Also gave them links to relevant websites where they could get more information in their own time so they could process that. And, you know, gave them a little bit of an insight as to what they were about to undertake as an administrator. I also mentioned to them that the member generally starts every hearing with an acknowledgement to country, which feedback from that when an acknowledgement is done has been really well received, and it shows that we are really listening to what our community has said, and that helps. We advise them how to address the member and encourage them to ask questions at the time if they needed further clarification on anything. That's the time to do it. Don't be too ashamed. You know, speak up, ask, and hopefully you'll get it answered on the day, not walk away still not knowing. These conversations that we have with community is really important because it can mean the difference between our mob coming to VCAT or not. So we work really hard to make sure that they're included in the process and we hear them. I'll continue to support that matter as long as it goes on. You know, it'll be reassessed down the track, and hopefully I'll be there to do, you know, do whatever support I can for the family as it goes on. Moving on to residential tenancies, you know, that's getting busier now since the end of the rental moratorium. We only had a few RT cases on our books, but now we're getting a few more. We've seen a significant jump in cases being listed and a variety of matters are being heard at VCAT, and we've seen a really big increase in inquiries coming through the Koori helpline. We contact all of the Koori parties, usually by phone, and offer support once the matter has been listed and it's got a hearing date. So we, you know, make sure we know, ask them if they're going to turn up and encourage them to turn up on the day, because if you don't, you're not likely to get as good an outcome. You know, if you don't attend, it's not helpful. You know, they've probably been through a lot of hardship before they even, you know, before we even get to chat to them. You know, many of our families come to us with complex needs. It's really important to make them feel comfortable so that they know they're not just another case number. They may have been dealing with job losses following the impacts of COVID, which has been pretty hectic, as we all know. There might be family violence involved, or they could be supporting other family members and possibly living in overcrowded households. We can provide referrals to relevant services to assist where possible, you know, but often they just disengage with us because it's become too much. So that's what we try to avoid. So keep them, you know, hang in there and we'll get through it together. You know, if they can come to VCAT and present their case, explain their circumstances, bring any evidence with them and try to negotiate with their rental providers to reach a repayment agreement, anything that it takes in order to keep their tenancy and keep a home, a roof over their head, because that impacts every other aspect of their life. So we encourage them to do that. VCAT has, I think, become more accessible during COVID. We've been able to do phone and video hearings for months now, which has improved attendance rate for our people, and particularly more so in regional areas in regional Victoria. And I'm hoping that having the Koori team on board here at VCAT is making it even more accessible to our community, and we can increase the confidence of VCAT staff and members to improve their interactions with members of the Aboriginal community as well. So that's really important. I just want to wrap up on a good news story, if you like. I recently attended a compulsory conference in a civil matter and supported the applicant. He was a young Koori lad who'd had ongoing issues with a car he purchased early last year. He waited, a long time to have his matter listed. He contacted VCAT and called out early that he was managing his mental health and that his anxiety may actually impact his ability to attend the hearing. This flagged him with Civil Registry for support from both our team and the disability liaison officers at VCAT. So we worked together to support him, to let the lad know that if he needed any adjustments made during the conference, that we could advise the member and request those adjustments be considered on the day if he needed to take regular breaks or things like that. Whatever it meant to get him through the day would be good. After many, many months of support and countless phone calls, emails back and forth, because he'd like to communicate by email, so we went with that, not phone. He had a fair bit of anxiety on the day, but he turned up to the conference. He was super organised. He had all of his documents ready. He had all his evidence, and then on the day he considered all offers that were put to him in the negotiation process, and he eventually accepted an offer. The matter was resolved on the day in just under 3 hours. So after all that time, it took that long. He was thrilled with the result, and this meant that he could now focus on his father, who had been extremely unwell and in and out of hospital. And he could also help his mother, who'd been struggling to keep up with all of the things going on at home. So he could focus his attention back to family. The lad was so extremely grateful for the support of the Koori engagement team at the time. And he said to us, I wouldn't have gone through with it if it wasn't for you and the team and the support that I got. And it's this type of feedback that we get from community that confirms to us that we are making a difference in people's lives. And as I said, it's our goal that the Aboriginal community feel supported to attend VCAT, to have their say, and to be able to be involved in matters that affect their lives so significantly. It's about where they live, who looks after them, managing their money and getting value from the goods and services that's important to them. So we want to support them through that. We are really looking forward to getting out and about to do more community engagement now that restrictions have eased, because that's how we do business really well, get out and do some face-to-face time with our mobs. So thank you for listening, and thanks for the opportunity to share a day in the life of a Koori support worker. Thank you.
Thanks very much, Kim, and thanks, Wendy, as well. And I mean, there's really a few things that really stick out to me hearing from both of you. And I guess from Wendy, the thing that is especially striking is just, as I was saying at the beginning, how much has been achieved over the last year by her and her team. And if you consider that in December 2019, we didn't really have a Koori support team at all. We didn't have any dedicated information for our Koori users on our website. We didn't have any Koori hearing rooms. We've now got 3 of those. We've got a dedicated Koori landing page on our website, and we've got a fully fledged and fully operational Koori support team in place. That's really, a significant turnaround in the service offering at VCAT. So it's really good to kind of get that summary and a reminder of just what has gone on. And then from Kim, I guess the things that are sort of really stand out as themes, or the main thing really is that, and this is common to a number of areas of VCAT's practice, because we deal so much with vulnerable people as well, and self-represented litigants, that the process is really equally as important as the outcome often. And that if people feel respected in the process, if they feel that they've understood it, and critically, if they feel that ultimately that their voice has been heard and validated, that can be as important as getting a successful outcome by a legal standard. And it can also really be important to preserving relationships, preserving people's self-confidence even. So that's really why we're doing this work in many respects. So it's great to get those personal insights and anecdotes about some of the specific cases that Kim and the team have been dealing with. The other area where, we can make a significant difference is obviously in the hearing process itself, and that's where our members really come in. So we've invited along Sid Fry, who's uniquely well positioned to speak about that role of the members. Sid's been with us since 2008, I believe, and he's one of what we call our sessional members, which means he works for us basically 1 day a week. And works in another job the remaining time. But since that time, Sid has been really worked across all of the VCAT list just about, I think. Started in residential tenancies and civil claims, but I think has a particular focus now on guardianship matters. Sid was the first ever Aboriginal person to be appointed as a VCAT member, is now one of two. And Sid, I'd like to welcome you to the discussion now. And I guess I thought it would be useful and interesting for the audience to hear, firstly, a bit about your background, your experience, and in particular, just sort of tell us a bit about how you found yourself in the law and how you found your way to VCAT.
Thanks, Warwick. Yes, big questions. Hard to follow the two ladies I've just been speaking that have just spoken before me, but I suppose if I'm look about how I found my way into getting into a legal career, it probably started a long time ago. As a kid, I had a lot of encouragement, or my mum encouraged the whole family to believe that we could be or do whatever we wanted to be or do, and I believed her. She made a lot of sacrifices to ensure that all six of us got an education and that none of us were left out. She often told us that being black was not an obstacle, but that's not exactly what some of the teachers were telling us at school. So I believed her though, and I've followed what she sort of put in place for us. I think she saw some of the potential in me to have a professional career, and she nurtured that. I don't think she wanted me to be a tradesman, but I ended up on the right side of what she wanted me to do. So one of the main reasons for that was probably because I used to love to read and write, and of course draw. We like to express ourselves with our art. And around about, I think it was around about grade 5 or 6, I used to read my older sister's English books at school when she was in secondary school. I used to help her with her book assignments. I used to correct the spelling. I'd edit, I'd rewrite, do things like that to make sure that she did all right. I don't think she actually ever read any of those books, but I did. And I paid a lot of attention to the arguments and the research, and I think she did okay. I can't remember what sort of score she got, but with my help, it gave me a purpose, and I always felt that, I liked the idea of helping people, particularly my own family.
So obviously there's a bit of a predilection for the law there. How did you sort of, what was your sort of pathway to get to becoming a VCAT member ultimately? I understand, you started out as I think only the second Aboriginal person to graduate from Melbourne Uni Law School?
Yeah, that's correct. I worked in a bank for 4 years before I started doing doing a law degree, but I always had a little inkling for law. And my sister, not the one I just referred to, but my other sister, she and my girlfriend, who became my wife, convinced me to apply for entry into the University of Melbourne through their mature age entry program for Aboriginal students. I also applied for the Moses scheme at Monash. I was successful in both, but I really wanted to try the University of Melbourne degree. I was provided with some practice aptitude tests. And then I was required to sit a 2-hour test with about 200 other people. Those 200 people, 4 of us were Aboriginal. I found out later that 4 of us were Aboriginal. 2 of us passed, and we were admitted into the Bachelor of Law degree at Melbourne University. Of course, that was with some restriction. We had to enrol as full-time students. We had to do the straight law degree. So at the time, to me, it felt like it was sort of set up to fail. I thought that the university was intimidating enough without further restrictions. And I could have easily walked out after my very first lecture, which had I walked in, I sat down, I got there early, I got a seat, and there were about 100, 115 students that walked in, and I'm thinking, God, this is a huge class. Then when the lecturer walked in, he advised everyone that this was was the MLC 113 torts, and if that's not what you're supposed to be here for, then there's the door. And thankfully, most of them left. But that was my first lecture, but I felt very intimidated. I wanted to walk out after day 3 because I was alone and lonely. Didn't feel like there was anything there to support. They did have an Aboriginal engagement unit, but you had to have an appointment to go and see them. So eventually I just crashed it and went there, and I spent most of my time there, and they helped me through some of the processes, and of course so did my wife and family. So, but if it wasn't for my sister and my girlfriend, I probably would still be working in a bank.
Yeah. Those sort of echoes of what we're talking about today, really, in terms of, the lack of institutional support and what a difference that can make in some ways. And then, so post-graduation, I understand you actually found yourself back in some ways in education, really, and teaching people.
I practiced for a couple of years in Warragul in a general law firm, and I ended up doing a bit of crash and bash family law, but my specialty was bankruptcy. So I got to know a lot about bankruptcy. Then, of course, I went back to I teach at the Institute of Career Education, part of Deakin University, where they started a law program, and I was one of the 2 lecturers that they had involved, and we ran the whole show with that. I worked there for 13 and a half years, and I'm pretty proud to say that we got 16 graduates in that period of time, which doesn't sound like much, but as you alluded to a moment ago, Warwick, Melbourne University had 2 law graduates in 150 odd years of law.
Yeah.
So,
yeah, that's a huge change. Yeah. So, I guess that sort of brings us to, roughly around the time of your appointment to VCAT, which is, around 2008, I guess. And so, given that you've been with VCAT for those 13 years, I'm wondering if we can now sort of start thinking about, and if you could offer some reflections on what you think are some of the barriers for Aboriginal people coming to the legal system and to VCAT in particular, and what their experience looks like overall.
I thought long and hard about this, and I could talk all day, possibly. Yeah. Really, if I just pop it in a nutshell, that I could probably basically just want to say that the legal system hasn't really been our friend. If you can't remember back, but Blackstone's commentaries, they may have been intelligible for the layperson at the time when they came over with the First Fleet, but they weren't much help to our mob. We've had things like the doctrine of terra nullius, which was used to dispossess us. Then we had the Mabo case, which at common law overturned it, but then again, Parliament stepped in and they watered down the result of that through legislation. So, that's just an example. We've also had the protectionist laws, which were used to control us. They denied us our freedom of movement, freedom of labour, custody of children, control over our own personal property, and a lot of other basic human rights. And we've had different things throughout that whole period of time up till now, but we're still overrepresented in prisons and we're still dying in custody. So I guess in a nutshell, we have an innate distrust in the law, a distrust in the police, a distrust in the courts and any form of authority. It's not everyone, but that's the basis of where we come from. And, as I mentioned with my mum, she made a lot of sacrifices to make sure that we weren't, involved in some of the activities or things that happened in my little country town. When it comes to VCAT, not now, but when I first started, and I claimed 2008, even though I was appointed in December of 2008. I'll take the whole year. When I first started in VCAT, a lot of people didn't know what VCAT was. The only thing they ever knew about VCAT was that it had a planning and permit side, and they knew that because you'd see things on the news about, I think you probably remember Sam Newman's big picture of Pamela Anderson on the front of his...
Yep, out the front of her house, in St Kilda.
Those sort of things. But that's the only thing that most people understood was a VCAT. And then, of course, they also thought, when I look at it, VCAT hearings in most areas are located in the Magistrates Court, and for us, that's a negative place to be. So there's probably a lot of other things I can say, but in a nutshell, that's basically what I saw from the beginning. Of course, that's all changed now with some of the new additions that we have.
Yeah, I mean, that was one thing I was going to ask you about is the extent to which, that division between civil and criminal matters is not that well understood in the community more generally, I think. I mean, and the fact of appearing, in a magistrate's court building can have that impact. Did you sort of see that there are that and other misconceptions about VCAT's jurisdiction amongst the Aboriginal people that appear in VCAT, or even more generally amongst self-represented litigants or other vulnerable cohorts?
Oh, for sure. It's the first thing you look at, and we like to talk amongst ourselves. I know people that just like to drive past the Magistrates Court in Geelong just to see which member of the mob is out the front having a smoke, ready to go in and have their case. And they just assume that it's a criminal case, or it's a family law case, or it's a violence case, or it's a child protection matter where their child's going to be removed. They just assume it. They don't think that it could be a civil matter.
Yeah, and in some ways, of course, the issues become intertwined at a certain point. Like it's often the case that people find themselves, in civil proceedings that sort of spiral into criminal matters, I guess. So there's always that issue as well about feeling that you're kind of on a conveyor belt that's going in the wrong direction, essentially, when you get into a civil matter.
Yeah. Some of the civil matters can be associated with a criminal element as well. So they can often find themselves there for 2 or 3 different cases that all related to the same incidents.
Yeah, and so Sydney, I mean, you obviously mentioned, and obviously we heard from Wendy and Kim earlier, but just you mentioned some of the changes we've had. But even prior to the establishment of the Koori support team, or up to now, what have you seen that's sort of been encouraging? What are some of the changes or improvements that you've witnessed in your time with VCAT?
With VCAT, well, first of all, I'd like to say it's about time they started doing something like this. Like, we've had Koori courts for quite a while, and we've had Koori hearing rooms in magistrates courts and children's court, and more recently in the county court. They've got a great hearing room in the Geelong magistrates court, which would be, if I could claim it, I would put a flag on it and just use that for VCAT matters. But it's just been about time. Sorry, I forgot what the question was. I rambled on.
Yeah, I was just saying, what from your point of view, I guess, what are the really substantial material changes that you've witnessed that are improvements basically over time? I mean, there's, I think, as we were saying, there continue to be barriers. There's undoubtedly a lot of work to be done. I mean, I guess if you compare now to where things might have been when you started, are there things that you'd really call out as significant shifts?
Well, when I started, there were quite a few members had no idea what NAIDOC was. Some of those things, or reconciliation, been around for a while, but no one ever spoke about it. But I think I noticed the changes. I think it was in 2013 when they were doing all of the consultation. It was towards the end of their consultation period when I can't even remember who were the consultants, but it was towards the end of their consultation period that they found out that VCAT had their very own Aboriginal member. So it was quite a surprise to them, but I'm glad they found out. They took the opportunity to come and talk to me. I got a feeling that something was going to happen and some things were changing. I know at the time that I was appointed, VCAT were trying to have more of a diverse range of members. And it was one of the reasons why I was approached to put in an application, which I did, and thankfully I jumped through enough hoops to get an appointment. So that was the starting point, and I suppose, I guess, I started to educate some of the members that were there at the time, and they often had questions. Not often, but if they had Aboriginal people that were going to be before them, they'd come and see me, or have a phone conversation with me to see if I could assist, which was really promising that they could do that. Some of them probably didn't. Some of them would have just let it go. But yeah, that's part of it. But most of the stuff that I see really is what what VCAT's doing in regard to empowering Aboriginal people to come and do their own thing. It's, you know, knowledge is power, and if we have the knowledge to do these things ourselves, we will do it. We've also got, you know, as mentioned earlier, we've got the website. You know, we've got a devoted team to help for help and support on the website. You just got 2 clicks and you're in. You know, open the website. There's a thing across the top that says Koori help and support. You press that again and you can access the Koori support. And I'm amazed to hear that we had 4,500 hits. That's just amazing. So it's gone from what I can see, it's gone from we don't even know what VCAT is to we know what it is now, and we're going to hit it. And that's due to the hard work that Wendy and Kim and their teams are putting in. You also, the application's much different now. It's much better because the application asks you the question a number of times. If you miss it, you know, do you or does the represented person, does the applicant, does whoever, do they identify as Aboriginal people? So that's great. And of course, having the 3 hearing rooms is even better. Although I still would love to steal the one in Geelong just for when I actually do my hearings there. And of course, the great thing about it is that VCAT employs Aboriginal people, not just in the Aboriginal engagement area, but we, you know, the support team, we've got other people throughout VCAT that, you know, support you. The Koori support team, as stated earlier, they support you all the way through. As soon as you tick that box and you come into VCAT, they're on the phone and they're ready to help you all the way through. And most importantly, for me as a member, is that they encourage people to attend. Attendance is a big yes for me. If you can get people to attend, the result, it may not always be in their favour, but it won't be as bad as it would have been if you weren't there. Like an example of that would be you get evicted. If you don't turn up, the landlord, or it's got a new name now, I can't remember what it is because I don't do residential tenancy.
Rental provider, I think.
Rental provider. They can get an order or a warrant as soon as they get a copy of their order, so they can finish in the hearing room, go and get a warrant, purchase a warrant, and go and have it executed the next day. If you turn up, you can apply or request for a 30-day stay on the warrant, up to 30 days maximum. And if you have a valid reason, you'll maybe get 30 days. At the least, you'll get a week, maybe 2. I usually don't give less than 2 weeks, depending on the circumstances. But yeah, there's lots of different things you can do. And they turn up now because of the use of technology. We've got text messages. That's a starter. Reminders. We've got telephone hearings, Zoom hearings. You can put your submissions in late if you've got some evidence that you didn't send in. You can send that in via email, and that'll get to the hearing room in time. There's lots of different things. What else have we got? We've got 100% increase in our Aboriginal members. That's great. You get a male view and the female view. You get lots of different views. We've got what else have we got? Cultural awareness, cultural competency training for the non-Aboriginal members, as just stated. We have a self-determination plan, but for me, and the part, because I'm as a member, I think for me, the best thing that we've got is the Koori reference group. And with the Aboriginal service providers that or organisational stakeholders, they're there. If they have issues, they can talk to us, and we can work through those things. We can say they can influence what we do to improve what we have, and they're the people that they're on the ground with our clients or participants that come to VCAT.
Yeah.
And I like that because I'm the co-chair or one of the co-chairs with yourself, Warwick. So it's
yes, that's right. Yeah, it's terrific. I know. We haven't talked a lot about the reference group, Sid, but actually I was thinking maybe that might be a good point to bring Wendy in, because I was just thinking about the fact that, so much of this work is kind of done out of the courtroom, really. It's done in the community. It's done before people even really have a claim. Sometimes it's about, working with the support agencies, working with the communities. So Wendy and perhaps Kim as well, I'm just thinking about, what do you see your role in terms of that building that profile and getting out to people, and I know that's been difficult during COVID, but how important is that, I guess, is the question.
Thanks, Warwick. I would say that we've relied very much in this in these last year and so since commencing the team on our networks and spreading the news of what the Koori Support team does through our networks. We have had an opportunity to, for example, go on 3KND radio. Kim and one of our Koori Support officers, Tracy Winmar, went on 3KND, for example. We've been in newsletters for some other organisations and stakeholders as well. But the Koori Reference Group means that we do have that regular contact with those key stakeholder organisations like Aboriginal Housing Victoria and the Victorian Aboriginal Legal Service, and in the Koori family violence space, Elizabeth Morgan House, for example. And they've been great channels for us too, so that while we think of people who, through our referral pathways, we're referring out, but at the same time, they're referring people into our Koori support teams as well. So that's really, I think, along with OPA, the Office of the Public Advocate, and others that we work with really closely, that's where, I guess, we've done those foundational activities to the best of our ability, but we are excited about the prospect of, the reopening of a vaccinated community, so that we can really get out and do that that community engagement when it's safer to do so. Absolutely.
Thanks, Wendy. And Sid, just coming back to you, I suppose we've only got a couple of minutes to go, but I was just thinking about the topic of cultural safety, and I mean, a lot of what you talked about before really picks up on that theme. The use of culturally safe hearing rooms, Koori hearing rooms, is obviously one aspect of that, is the built environment. But as you were saying, I mean, a lot of the way in which we're currently delivering our services, and probably will continue to do it, is done via remote means, via technology. So there's a whole other dimension to cultural safety, which is around the way people experience the process of the hearing and so on. So I'm interested in how, if you have Aboriginal hearing before you, how do you like to run your hearings? How do you engage with the parties in that situation?
Well, I run the hearings the way I like to run the hearings, whether they're Aboriginal participants or not. Although I do a acknowledgement. I'd love to do a welcome to country in my own area, being Wajbala Kunditjmara. So if I ever get the chance to be in Horsham or up Warrnambool Way, then I can, rather than do an acknowledgement, I can actually do it as a welcome, so that they feel better. I always wear. I've got a heap of Aboriginal design ties. My daughter supplies them to me for Father's Day. So I get them. I wear them every time I sit. I've got a few members that have shown interest in wearing them, so I've given them a tie as a present. And every time I see them, I'm proud to say that they are actually wearing them. I don't know if they check the roster to see if I'm on and just wear it on those days, but I'm pretty sure they don't, the ones I know. As I said, I commence with a welcome to country. Sometimes I'll greet participants with a traditional Aboriginal greeting, just nada or natnwa or dog. So it sort of gives an indication. Sometimes I do a little bit of mouth movement for the Aboriginal people so they know who I am. Sometimes I'll say something like, say something like deadly or whatever in a thing. Other people may not pick it up, but they might pick it up. So they know that I'm there. I don't, if they're elders in front of me, I don't call them uncle or aunt, but that's because I don't want to appear like there's bias in my hearing room. So because there's no bias, I treat everybody the same. I like to inform everybody how my hearing is going to run, how I plan to do it. what else do I do? I tell them that how I'm going to conduct it, how they should address me, that they should be respectful to everybody there. So I basically set the scene to say that I'm in control of this hearing and you're safe in my presence. Then I let them know that I remind the parties that I'm bound by the rules of natural justice, but I'm not bound by the rules of evidence, and I can inform myself of any matter as I see fit. I tell them if they don't listen to me, I can adjourn the matter or whatever. If they need to talk, if they want to question the other side, they must talk through me. So I try and control the hearing as much as I can so that everybody there, if they feel intimidated or beforehand, that I'm in control and they're not going to be intimidated. So yeah, most important thing is I try to ensure that all parties feel safe, comfortable, and they get an opportunity to be heard, because that's what they're there for. They want to be heard about what they're doing. So with regard to Aboriginal participants, I've not had any in guardianship at the moment. I've mainly had residential tenancy matters where they've been the respondent. I have evicted some, but I make sure that or make inquiries into the possibilities of referrals and other things that they may be able to link into, so that they're not left alone. This is probably prior to the introduction of the stuff that we have now. What else have I done? I've made payment plans. I've made reductions in some of the compensation claims that have been against them, and I've had to recuse myself 3 times, because once in a civil case, because the applicant was my cousin, and twice in residential tenancies, one of the respondents was my niece, or one of my nieces. I've got many nieces. And in the other case, I had just sworn the party in when my cousin's ex-partner came in to support his new partner, so I had to recuse myself. So, you do meet up with people at VCAT that are family members, and you have to do the right thing. But thankfully, on those occasions, the member in the other room was aware of it, or at least 2 of them, 3 of them, because I had informed them that I would have to recuse myself and they would go be in my hearing rooms. It's quite good.
That's good, thanks, Ed. And yeah, I mean, I think that's one of the risks we run when we deal with so many matters, that inevitably we're going to come across some issues where we know the party. So yes, it's always a bit of a challenge. But we've pretty much run to time, and I wanted to say, I mean, I think that it was great to hear some of the echoes of, I guess, of those themes I was talking about earlier in what you were just saying then, Sid, about being heard and about, you know, the process essentially, and how making a room in a process for respect and understanding and so on can have such a big impact on people. So thank you for all those comments. I think it just remains really for me to thank Sid for coming today and for sharing his reflections on his experience as a VCAT member. So thank Wendy, and to thank Kim, not only for their remarks today, but also for all the work they've done over the last little while, particularly during COVID, to really invigorate the career engagement program at VCAT. Also, just wanted to quickly thank our Stratcoms team for helping to set up this event. It's amazing how much work actually is involved in doing one of these things. After doing Zoom hearings for 14 months, you'd think we'd be have it running like a well-oiled machine, but it's actually surprisingly complicated. So thank you to them, and finally thanks to everyone in the audience. We can't see any of you, but I hope that it's been an informative session, and it is being recorded, so strongly encourage you to mention to anyone within your organisations or outside that it's available for them to view at a later stage. So that's it, I think, from us. Thanks again, and I hope you enjoy the rest of Law Week. Thank you.
Thank you.